Right now, 48% of Americans will leave behind digital accounts their family can never legally access. Not because of fraud, not because of a legal dispute, simply because no one planned for it. If you have a banking app on your phone, photos stored in the cloud, a brokerage account you log into online, or any kind of digital subscription, this video applies to you. And it applies to every single person in your family. Here is what happened to Sandra. Her husband, James, passed away suddenly at 61. A heart attack, no warning. He was healthy, active, and completely unprepared for what his death would do to his family. James had a will. He had a living trust. He had life insurance. By most standards, he was more prepared than the average American. But what nobody told James, and what no one told Sandra, is that his entire financial life had quietly moved online. His Fidelity brokerage account, worth $412,000, was accessible only through an app on his phone. The phone required Face ID to unlock. James was dead. The Face ID was useless. His Gmail account held 14 years of financial records, tax documents, and password reset links. Google's terms of service said only the account holder could access it. Sandra was not the account holder. His crypto wallet, just over $8,000 in Bitcoin, required a seed phrase stored only in James's memory. That seed phrase died with him. 18 months after James passed, Sandra was still in court trying to access the money her husband had spent 30 years building. The bank had done nothing wrong. The platforms had done nothing wrong. The law had done nothing wrong. The problem was that James's estate plan was built for 1,995, not for 2,026. Today, I am going to make sure your family never goes through what Sandra went through. We are going to cover exactly what digital assets are, why the law has a massive gap that most estate attorneys are still not addressing, and the specific steps you need to take in the next 30 days to protect your family. What counts as a digital asset? Most people think of digital assets as cryptocurrency. That is the smallest part of this problem. A digital asset is anything of value that exists in digital form and that you access through credentials, a username, a password, a PIN, biometrics. Here is what that actually includes. Your online bank accounts and brokerage accounts. Fidelity, Vanguard, Schwab, your credit union online portal. If your family does not have your login, they cannot access these accounts even if they are legally entitled to the money. A beneficiary designation gets them the funds eventually, but they may wait months and need to go through probate to prove it. Your email accounts, Gmail, Outlook, iCloud, Mail. These hold years of financial correspondence, password reset emails, tax documents, and insurance policy information. Lose access to email, and you lose the thread that connects to everything else, your social media accounts. Facebook, Instagram, LinkedIn. These are more than memories. They are digital identities that platforms will either memorialize, delete, or hold indefinitely, depending on their policies. Your subscriptions, Netflix, Spotify, Amazon Prime, Hulu, Adobe, Microsoft, 365. These accounts do not cancel themselves when you die. Your family could be paying for your subscriptions for months before they even realize it. Collectively, the average American has over $2,000 per year in active subscriptions, cryptocurrency and digital tokens. Bitcoin, Ethereum, NFTs, tokens stored in hardware wallets or on exchanges. This is the highest risk category because there is no bank, no customer service, no court order that can recover access if the credentials are lost. PayPal, Venmo, Cash App, Zelle. Small balances add up, and these platforms require a death certificate and legal authority to release funds, and that process is not straightforward. Cloud storage, iCloud, Google Drive, Dropbox, OneDrive. These often hold irreplaceable photos, videos of loved ones, business documents, and personal files. When access is lost, it is gone forever. Password managers, the master key to your entire digital life. If your family does not know your password manager login, they lose access to every account connected to it. Online businesses. If you sell on Etsy, Amazon, eBay, or operate a website or blog, those are assets with real monetary value. They need to be transferred just like a physical business. Airline miles, hotel points, loyalty rewards, American Airlines A-Advantage miles, Marriott Bonvoy, points collectively worth hundreds or thousands of dollars. Many programs have policies about transferring miles after death, but only if you follow the right process. If you have ever created an account on a platform and stored value there in any form, that is a digital asset. And right now, most estate plans treat none of them. the legal gap no one is talking about. You might be thinking, if my executor is legally authorized to manage my estate, can't they just access my accounts? The answer is, legally yes, practically no. In 2015, a law called the Revised Uniform Fiduciary Access to Digital Assets Act, known as RUFADAA, was introduced to address this exact problem. 47 states have now adopted some version of it. On paper, RUFADAA gives your executor the legal authority to access your digital assets. Here is the problem. RUFADAA defers to the terms of service of individual platforms. And those terms of service say that only you, the account holder, are authorized to access the account. Google, Apple, Meta, and most major platforms have built their own internal processes for handling account access after death. Those processes are slow, require extensive documentation, and often result in families being denied access anyway, not because the law failed them, but because the platform's internal policies take precedence. Apple will give a designated legacy contact access to your account, but only if you set that legacy contact up before you die. If you never set it up, Apple requires a court order, and even then will only provide limited access. Google has an inactive account manager feature that allows you to designate trusted contacts and specify what they can download. But again, you have to activate it before you die. If you never touch that setting, your executor faces a months-long process with no guaranteed outcome. Facebook offers a legacy contact who can memorialize your account or request deletion. Without that designation, your account could sit active indefinitely, or Facebook may memorialize it automatically based on information from a death certificate, but access to your messages, photos, or private content is almost never granted to family. And cryptocurrency. RUFADAA does not apply to crypto held in self-custody wallets. Blockchain does not recognize court orders. If you hold your own crypto and no one knows the seed phrase, those funds are mathematically inaccessible. Forever. The law created a framework. The platforms ignored most of it, and the result is a legal gap that is costing American families billions of dollars per year in lost digital assets. 5 documents your estate plan is missing. If you have a will, a trust, a power of attorney, and a healthcare directive, you have the foundation of a solid estate plan. But none of those documents, as written, cover digital assets unless someone specifically added language for them. Here are the 5 things your estate plan needs right now. Number 1, a digital asset clause in your will. Your will needs to specifically authorize your executor to access, manage, and transfer your digital assets. Without this explicit language, many platforms will reject requests from executors even when they present the will. The clause should name the types of assets covered and grant broad access authority. Number 2, updated durable financial power of attorney. If you become incapacitated, not dead, just unable to manage your own affairs, your power of attorney agent needs to handle your digital accounts. Most standard POA forms were written before online banking was the norm. They do not mention digital assets. Your attorney needs to add a specific digital access provision. Number 3, a digital asset schedule in your revocable living trust. Your trust controls what happens to your assets outside probate. Add a digital asset, schedule a list, updated regularly, that describes your accounts, where they are held, and how to access them. The trust document itself does not need to contain passwords, it just needs to reference the schedule and the letter of instruction. Number 4, a RUFADAA authorization form. Some states and some platforms respond better to a standalone RUFADAA authorization, a specific document that grants your fiduciary explicit permission under the Act. Your estate attorney can draft one in under an hour. It costs almost nothing and can cut through months of platform bureaucracy. Number 5, a letter of instruction. This is not a legal document. It does not get filed with a court, but it may be the most important thing you leave your family. A letter of instruction is a plain English guide to your digital life where everything is, how to access it, and what to do with it. It is updated regularly, stored securely, and given to your executor or trustee separately from your will. We will talk about exactly what to put in it in a moment. Building your digital inventory, the letter of instruction lives or dies on one thing, a complete digital inventory. Here is what it needs to contain. Start with your master password. If you use a password manager, and you should, your executor needs the master password to unlock everything else. This one password is the skeleton key to your entire digital life. It should be written down, not typed, written and stored in 2 places, a fireproof safe at home and with your estate attorney in a sealed envelope. Next, document your devices, every phone, tablet, laptop, and computer in your household. List the PIN or password for each one. If your executor cannot unlock the device, They cannot access anything on it. Document all financial accounts, bank accounts, brokerage accounts, retirement accounts. You access online the institution name, the login, email, and a note about where to find the password in your manager. Include the account number if you have it. List all subscriptions. Go through your last 3 months of bank statements and credit card statements. Write down every recurring charge. Note whether each one should be cancelled, transferred, or continued. Crypto deserves its own section. For each holding, the name of the cryptocurrency, the platform or wallet where it is held, the wallet address, and, critically, where to find the seed phrase or private key. Never store the seed phrase digitally. Write it on paper or engrave it on metal. Store it in a fireproof safe or with a trusted person in a sealed envelope. Make clear in your letter of instruction exactly where the seed phrase is. Document your legacy contact settings. Note whether you have activated Apple Legacy Contact and Google Inactive Account Manager. Provide the name of the designated person. If you have not activated these, make that the first thing you do after watching this video. Finally, document your social media wishes. Do you want your Facebook account memorialized or deleted? Do you want your Instagram archived or taken down? Do you want your LinkedIn profile removed? Write it down. Your family should not have to guess. 5 mistakes that lock your family out. Mistake number 1, putting passwords in your will. This is the most common mistake people make when they try to address digital assets on their own. Your will becomes a public document when it goes through probate. Putting passwords in a public document is a security disaster. Your passwords belong in a letter of instruction, stored securely and separately from your will. Mistake number 2, relying entirely on biometrics. Face ID and fingerprint readers are convenient. They're also tied to a living body. When you die, your phone is useless to anyone without a PIN backup. Make sure every device has a numerical PIN as a backup, and make sure your executor knows it. Mistake number 3, naming a minor child as a crypto beneficiary. A minor cannot legally hold cryptocurrency. If you leave crypto directly to a child under 18, a court will appoint a guardian to manage it, and that process can take months and cost thousands of dollars. Use a trust to hold crypto for a minor beneficiary. Mistake number 4, assuming your family will figure it out. Tech companies are not family-friendly when it comes to account access. Their legal and trust and safety teams are trained to deny access requests. They have been sued over this. They have policies specifically designed to limit liability by refusing access. Your family will not charm their way into your accounts. Planning is the only answer. Mistake number 5, thinking your beneficiary designation covers your online account access. A beneficiary designation on your Fidelity account means Fidelity will eventually transfer the funds to the named beneficiary, but it does not give your beneficiary login access to the account. Until the transfer is complete, which takes weeks, they are locked out. The solution is to name a beneficiary and give your executor the credentials. The crypto problem? I want to spend a moment on cryptocurrency specifically because it is the most dangerous area of digital estate planning. It is estimated that over $140 billion in cryptocurrency has been permanently lost because the owners died without leaving their seed phrases or private keys to anyone. That is not a typo. $140 billion, mathematically inaccessible, sitting on blockchains that will exist long after the last person who knew the password is gone. Unlike a bank account, there is no phone number you can call, there is no fraud department, there is no account recovery process. The blockchain does not know or care that you died. Whoever holds the seed phrase holds the money, period. If you hold crypto on an exchange like Coinbase or Kraken, you have some protection, the exchange holds your keys, and can be contacted by your executor with a death certificate. But even exchanges have inconsistent policies for account transfers, and the process often takes months. If you hold crypto in a self-custody hardware wallet, a ledger, a Trezor, a cold card, your seed phrase is everything. Without it, the funds are gone. That seed phrase needs to be written down, stored offline, and placed somewhere your executor can find it. A fireproof home safe plus a duplicate in a bank safe deposit box or with your attorney is the minimum standard. Do not photograph your seed phrase. Do not store it in your email. Do not save it in a note-taking app. Offline, physical, secured, those are the only acceptable options. Your 30-day digital estate plan. Everything we have covered today can be addressed in 30 days if you take it 1 week at a time. In week 1, set up a password manager if you do not already have one. Bitwarden is free. 1 password costs about $3 per month. Import every account you have. Make sure your master password is strong, written down, and stored safely. This one step protects everything else you do. In week 2, activate Apple Legacy Contact and Google Inactive Account Manager. Both take under 10 minutes to set up. Go to your device settings right now. For Apple, go to Settings, tap your name, tap Password and Security, tap Legacy Contact. For Google, search Inactive Account Manager and follow the prompts. Name your trusted contact. Set a time frame. Done. In week 3, create your letter of instruction. Use what we covered today as your outline. Document every account, every device, every subscription, your crypto holdings, and where the seed phrase is stored. Store 1 copy in a fireproof safe. Give 1 copy to your estate attorney in a sealed envelope. Tell your executor it exists and where to find it. In week 4, contact your estate attorney and ask them to add a digital asset clause to your will, update your power of attorney to include digital assets, add a digital asset schedule to your trust, and draft a RUFADAA authorization form. If you do not have an estate attorney, this is a good reason to get one. The cost of adding digital asset provisions to an existing plan is usually between $300 and $800, a fraction of what your family will spend fighting for access if you do not do it. 48% of Americans will leave their families facing a digital lockout. The banks will follow their rules, the platforms will follow their policies, the law will do what it can, which is not enough without advanced planning on your part. James had a will. James had a trust. James had life insurance. But James did not have a digital estate plan, and Sandra spent 18 months in court fighting for money that should have taken 18 days to access. You know what to do now. The question is whether you do it. If this video helped you understand something your current estate plan is missing, subscribe to Benefits Decoded. New videos every week on protecting what you have built for the people you love. I am Marcus Webb, and your family's financial future is worth one afternoon of planning.